Hello everyone, my name is Zoe Gunari and I'm the module leader for the module called International Sale of Goods. In this presentation, I'm going to tell you how the module is delivered, what it is about, what it covers, and finally how it is assessed. To begin with, I will be the sole lecturer on this module, which takes place in the second semester of the academic year. The module will be delivered primarily through small group teaching. Specifically, we will cover the curriculum over 10 two-hour seminars. You will also have the opportunity to ask any questions on your understanding of the material in 4 one-hour Q&A sessions, which will be set over the course of the module. And finally, you will be able to track your knowledge and understanding of the material through multiple choice quizzes. Now let's see what the module is about. The module covers the law pertaining to the international sale of goods, which is conducted on the basis of either English law or the terms of the United Nations Convention on the International Sale of Goods of 1980, also known as the CISG. The reason we will be covering English law is because English law is commonly used to resolve international sales disputes, particularly in commodities transactions. The CISG, on the other hand, has been adopted by over 80 countries and has informed the laws of a number of others, including, for example, the Chinese contract law of 1999. Now, against this background, we will cover a range of topics pertaining to the contract of sale. First things first, we will examine the core concepts of the law of sales. We will then cover the default terms of the sales contract, which govern key points, such as the duties of the buyer and the seller, the passing of risk and title in the goods, and the remedies of the buyer and seller in case of breach. Now, in the context of contract breach, we will also consider the availability of possible defenses, and specifically, we will examine the effect of frustration and force majeure on the parties' obligations. Now, in the same vein, we will examine the key dispute resolution mechanisms, and in that context, we will consider relevant aspects of the conflict of laws. Specifically, we will examine the rules governing the questions of applicable law and jurisdiction, and finally, the rules pertaining to the enforcement of foreign judgments. Now, let's look at how the module will be assessed. The module is assessed by written exercise and a multiple choice exam. First things first, the written exercise will have a word limit of 3,000 words. As part of the exercise, you will be required to draft a set of contract terms in response to a commercial scenario and explain why you have drafted those terms in the way that you have. This will take up 70% of the final mark for this module. Finally, the second aspect of the assessment is a multiple choice exam, which will consist of a number of multiple choice questions arising from one or more commercial scenarios. This will take up 30% of the final mark for this module. And this now concludes my presentation on the international sale of goods. Now, if you have any questions on the module, please do not hesitate to contact me at this address. Thank you very much.